Every legal encounter leaves a trace. Every strict investigation pursues honesty. Comprehending your legal rights, establishing true justice.
You think you're smart? You think you can step over me and make the calls? I've been on this job 20 years. You are nothing. You don't even deserve to wear that patch. I know exactly how you got this job, and it wasn't skill. You don't belong in my car. You keep your mouth shut next time, or I'll make sure you lose that badge. You hear me?
There was a camera recording when those words were said. It had not been planned that way. There was no deliberate setup, no preparation to document what was about to happen on that highway, under that intense blue summer sky. The camera was recording because body cameras record, because that is the protocol, because the person carrying it on their chest had activated the recording the moment they stepped out of the car, the way training teaches you to do, automatically, without thinking, because that is what you do. And then, in a sequence of events that camera would capture with the specific fidelity of devices that do not distinguish between what should be documented and what should not, one officer had looked at another officer and had said two words the camera had recorded with the blue sky behind them, and the highway stretching beyond them, and the summer sun making every detail sharp and irrefutable. You are nothing. The camera had captured that, and everything that came after had begun there. The person who had heard those words was named Officer Marcus Webb. He was 34 years old, had served in the city's police department for 7 years, had received 2 commendations for exemplary conduct, and had left home that morning with his uniform, his duty belt, the body camera clipped to his chest, and the expectation of an ordinary shift on a highway he knew well, because he had worked that route frequently enough to know where the asphalt was worn and where the signage needed maintenance. It was an ordinary service day, until it was not. Until another officer had pulled up beside his cruiser on that open highway and had said those 2 words with the camera recording and the sun beating down and the empty highway in the background as a silent witness to something that should not have been said and that, having been said, could not be undone. The officer who had said those words was named Officer Derek Stone. He was 41 years old, had served in the same department for 12 years, and had arrived at that highway that day in a dynamic that the subsequent lawsuit would describe with a precision that made any argument about ambiguity or misunderstanding impossible. Stone had approached Marcus not because there was an incident requiring intervention, not because there was an ongoing procedure that needed reinforcement, not because any operational protocol had created a legitimate reason for that specific encounter on that specific highway at that specific moment. Stone had approached Marcus because he had seen a black man standing beside a police cruiser and had made a decision about what he was seeing before processing any other detail of the scene, including the uniform, the body camera, and the badge that were visible with the same clarity as the color of Marcus's skin. There was a specific irony in the architecture of this case that legal commentators and journalists who covered it in the weeks after the video became public had noted and described in different ways, but that converged on the same point, that the camera that had captured Stone, saying "you are nothing," was the camera that belonged to Marcus. That was the camera of an officer on duty being treated as though he were not an officer on duty. That was the camera of someone being told they were nothing, recording the person saying it. There was in that inversion a documentary completeness that no subsequent reconstruction could improve because the recording already contained, in the very mechanism that had produced it, the most direct refutation available of what had been said. The camera of someone who is nothing does not exist. That camera existed, and it was recording. If this is your first time on this channel, welcome. This case has a dimension that separates it from others. This channel has examined because here, it is not a citizen being treated differently by an officer. It is an officer being treated differently by another officer. And what that reveals about where prejudice begins and where the uniform ends is something that will stay with you after this video ends. Hit subscribe right now and tell me in the comments, do you think a black officer should have to prove to a white colleague that they belong in the profession both of them chose? Tell me down below. The $200,000 the department paid to resolve the lawsuit that followed those 2 words was a number that had several ways of being read, depending on who was reading it. For some, it was a number too high for 2 words said on a highway. For others, it was a number too low for what those 2 words represented. But there was a reading that the attorneys who conducted the case described as the most accurate available, that $200,000 was the amount the department had calculated was preferable to pay a colleague who had been called nothing than to go to trial with a body camera, showing a uniformed officer saying, "You are nothing," to another uniformed officer on an American highway on a sunny afternoon. That calculation had said something about the case, and the camera had said the rest. Marcus had arrived at that highway that afternoon as the result of a dispatch routing call that had sent his cruiser to that specific section of the road as part of the shift's regular patrol coverage. There was no active emergency, no pursuit, no ongoing incident that had created that moment. There was only the geographic distribution of resources that dispatch does automatically on patrol shifts. And there was Marcus in the cruiser, with the uniform and the camera and the badge doing what officers do when there is no specific call, covering the route, observing, being a visible presence on an open highway on a sunny afternoon. He had stopped the cruiser on the shoulder for reasons the shift records would document as a routine check of a vehicle that had drifted slowly from the flow of traffic, had stepped out of the cruiser, activating the body camera with the automatism of someone who had made that gesture enough times for it to have stopped being a conscious gesture, and had stood beside the cruiser while the vehicle that had drawn his attention continued and disappeared on the horizon without incident. It was at that moment, with Marcus standing beside the open cruiser on the highway, that Stone's cruiser had appeared. Stone had slowed down as he passed the scene, had looked at Marcus, had continued for perhaps 200 meters, and had turned back. That return had been captured by Marcus's camera, which had been active since he stepped out of the car, and it was a detail that Marcus's attorneys would identify as the most revealing detail of the sequence preceding the words, because a deliberate return after an initial pass is not the behavior of someone responding to an incident. It is the behavior of someone who saw something, formed a conclusion, and came back to act on that conclusion. Stone had parked his cruiser behind Marcus's, had stepped out, and had walked toward Marcus with that specific posture Marcus's camera had captured and that anyone familiar with this kind of recording would immediately recognize as the posture of an approach, not of a colleague approaching another colleague, but of an agent approaching a situation they had classified as needing intervention. Marcus had perceived the approach with the training of someone who had spent 7 years developing the capacity to read situations before they became explicit. He had remained standing beside the cruiser with his hands visible, had turned his body slightly toward Stone as he approached, and had waited. Stone had arrived at a distance Marcus's camera captured as the distance of a formal approach, not the distance of a conversation between colleagues on a highway shoulder, and had asked for identification. He had not said hello. He had not asked if help was needed. He had asked for identification with the tone of someone conducting a suspect approach who had not yet recognized, or had recognized and chosen to ignore, that the man in front of him was wearing the same uniform he was, carrying the same badge he was, and had the same camera clipped to his chest that he did. Marcus had responded by identifying himself by name and badge number, which was the functional identifier officers use when communicating with each other in professional contexts, and had pointed to the badge that was visible at chest height. Stone had looked at the badge, had looked back at Marcus's face, and had done something the camera had captured and that had been analyzed by police behavior specialists when the video became public as one of the most indicative elements of the nature of what was happening. He had asked to see the identification again, this time specifying he wanted the full identity with verification, the kind of request made to a member of the public during a suspect approach, and not the kind of acknowledgement extended to a uniformed colleague on a highway shoulder. Marcus had removed the identification holder with controlled movements, had shown the complete credential, and had waited while Stone examined it with the expression the camera captured as the expression of someone receiving information that conflicts with the narrative they brought to the encounter, and who has not yet decided how to integrate that conflict. The camera had kept recording during the silence that followed the examination of the credential. It was a silence of perhaps 8 seconds that had seemed longer in the recording than 8 seconds normally seemed, because there was in it the specific quality of a moment where something was being decided without any of the words of that decision being said out loud. Marcus had remained still during that silence with the credential still in his hand, the highway stretching behind Stone, the sun hitting Stone's dark glasses in a way that made the expression of his eyes impossible to read, but that made the posture of his entire body entirely legible on camera. And then Stone had said the words the camera had captured, And that had become the caption of the video and the reference point around which all subsequent analysis of the case had orbited. He had looked at Marcus, had looked at the badge, had looked back at Marcus, and had said that with that badge or without it, with that uniform or without it, Marcus was nothing. You are nothing. 4 words said. With the blue sky behind them, and the body camera recording, and the American highway stretching on the horizon as if the entire world were a witness, and at the same time were no witness to anything at all. Marcus had remained completely still after hearing that. The camera had captured that moment with the detail cameras capture when the subject of a recording is containing something that containment can barely hold. He had put the credential back in the identification holder with the same controlled movement with which he had done everything else that afternoon, and had said a single sentence the camera had recorded with enough clarity to be transcribed, a sentence that had not been aggressive or said in anger, but that had been said with the precision of someone who had made a decision about what they were going to do with what had just happened. He had said that the conversation was being recorded and that Stone's identification number was being noted, and that everything said on that shoulder would be documented. Stone had looked at the camera on Marcus's chest as if seeing it for the first time. Although there was an identical camera on his own chest that had been recording from the same angle the entire time. Stone had left the shoulder without another word, after Marcus had said everything was being recorded. Marcus's camera had captured that departure. Stone returning to his cruiser, the door closing, the cruiser pulling away on the highway with that disturbing normalcy of something that had just happened and that continued existing only in the recording and in the memory of the 2 men who had been present. Marcus had stood on the shoulder for a moment after Stone's cruiser had disappeared on the horizon. The camera had captured that moment too, the shoulder, the highway, the blue sky, and Marcus standing with the credential back in his pocket and the camera still recording because the camera did not know the relevant part had ended and kept doing what cameras do. Marcus had gotten back into the cruiser, had sat with the engine off for perhaps 2 minutes before turning on the radio and making the call he had decided to make the moment Stone had said those 4 words. He had called the shift supervisor over the standard radio channel, had asked for a private communication on the secondary channel, and had reported the incident with the factual economy that training taught to use in shift reports, identifying Stone by badge number, describing the location and time, and relaying the exact words that had been said. The supervisor had been silent for a moment after the report, then had confirmed receipt and said he would document it, and that Marcus should write the incident report when he returned to the station. There was something in the quality of that supervisor's silence that Marcus had noticed and would later describe with precision. It was the silence of someone who had immediately understood the seriousness of what they had heard, but who was still calculating what it meant institutionally before saying anything that committed to a position before there was more information. Marcus had turned off the radio, had started the engine, and had continued the shift. Because that was what you did. Because the shift did not end because something had happened on the shoulder. Because the highway was still there, and the service was still the service. The incident report had been written that evening before Marcus left the station. He had written with the same precision with which he had made the radio call, identifying each element of the sequence in chronological order, using the technical language that incident reports used and that made each detail verifiable and each allegation specific without unnecessary embellishment or interpretation. He had mentioned the body camera that had been active throughout the interaction and had included in the report the reference to the specific timestamp corresponding to the moment the words had been said. He had handed the report to the shift supervisor and had left the station that night with the clarity of someone who had done what protocol required and who now needed to decide what to do beyond protocol. Because protocol documented what had happened, but did not resolve what had happened, and there was a difference between those 2 things that Marcus had learned with sufficient clarity over 7 years of service to know that documentation was the beginning and not the end. Stone's body camera had been recording throughout the entire interaction the same way Marcus's had been recording, and both files now existed in the department's system as complementary pairs of the same scene seen from different angles. That detail, the simultaneous existence of both recordings, had been the element that the attorneys who took Marcus's case described as the most solid foundation they had found in a police conduct case because it eliminated the possibility of any argument about perspective or interpretation that cases without recordings frequently produced. There was no available perspective that made the 4 words ambiguous. There was no available interpretation that created a context where nothing said by one officer to another on a highway shoulder was part of any operational protocol or any professional interaction the department could defend. Both agents' cameras had recorded the same thing from complementary angles, and the only difference between the two recordings was that one showed Marcus receiving the words and the other showed Stone saying them, and both were equally irrefutable. The department had initiated an internal investigation 48 hours after Marcus's report, after the shift supervisor had escalated the case to the division commander, who had watched both recordings in a meeting with the department chief and the institutional legal counsel. It had been in that meeting, according to sources close to the process who described what had occurred without named attribution, that the legal counsel had said something that had changed the nature of the institutional response from a standard conduct investigation to something that was treated with a different urgency. The counsel had said there were 2 body cameras recording the same interaction, that both were on the department's servers, that any discovery process in any subsequent lawsuit would have immediate access to both, and that the institution needed to decide before any lawsuit existed how it was going to handle a recording that showed one of its agents saying, "You are nothing to a uniformed colleague on an American highway." He had been silent after saying that, according to the same source, letting the implication occupy the space without needing additional elaboration. Marcus had been contacted by an attorney specializing in police conduct cases and civil rights of law enforcement agents 3 days after presenting the incident report. Not because he had immediately sought legal representation, but because the attorney had been referred by a colleague of Marcus's who had gone through a situation involving discrimination in the workplace 2 years earlier, and who had told Marcus there was a fundamental difference between having a documented complaint and having someone who knew what to do with a documented complaint in an institutional context that had every incentive to minimize what had happened. Marcus had met with the attorney that week, had shown him the incident report, had described the interaction with the same precision he had used in the report and the radio call, and had told the attorney he wanted 2 things from the process that followed. He wanted Stone to answer for what he had said, and he wanted the department to answer for the environment that had allowed something like that to be said. The attorney had listened, had asked some questions about Stone's history, about prior complaints, about the department's culture, and had said at the end that he had enough to build a case and that the cameras made that case more solid than most cases he had conducted in his career. Stone's history that had emerged during the discovery process had a structure that Marcus's attorneys described in one of the preparatory meetings as the structure they saw most frequently in cases that reached the formal lawsuit stage. Not the structure of an isolated incident by an agent without prior history, but the structure of a pattern that had existed long enough to be documentable and that had persisted long enough to raise questions about the supervision that had allowed the persistence. There were 3 complaints in Stone's records from the previous 12 years. The first had occurred 4 years after the start of his service, and had involved an allegation of discriminatory treatment in a traffic stop that had been filed away after an investigation that records described in language that was technically neutral, but whose analysis of the volume of documentation produced suggested had been conducted with a brevity inconsistent with the seriousness of the allegation. The second had occurred 2 years later, and had been withdrawn by the complainant before a formal conclusion, which the records documented without additional detail about the circumstances of the withdrawal. The third had been an internal complaint from a colleague, not public, that had resulted in a verbal warning whose specific content was redacted in the records in a way that made it impossible to verify what had motivated the warning without access to documents the department had initially resisted providing during the discovery process. That initial resistance to providing the documents related to the third complaint had been one of the most revealing moments of the discovery process, according to Marcus's attorney, not for what it had eventually revealed when the documents were finally produced under court order, but for what the resistance itself had communicated about what the department knew was in those documents before any production order. When the documents had been produced, they had revealed that the verbal warning had resulted from a situation where Stone had made comments to a black colleague during a shared shift that the colleague had reported as racially motivated, and that the supervisor who had conducted the review had described in his notes, which were part of the file, as concerning but insufficient for formal disciplinary action. That specific document, with that specific language of concerning but insufficient, had become one of the most cited elements in Marcus's lawsuit because it established that the department had previously been informed that Stone had a pattern of behavior that had been internally classified as concerning and had chosen to respond with language that signaled recognition without consequence. Stone had been deposed in a context that Marcus's attorneys had prepared with full knowledge that the cameras eliminated the space available for alternative versions of events, but that still left space for the question of context and intent, which was the space where defenses in cases of that kind normally operated when factual evidence was irrefutable. Stone's strategy had been to frame the words as part of a training dynamic, suggesting he had known Marcus from prior contexts and had used provocative language as a form of pressure response testing, an allegation that had been dismantled during the deposition by 3 sequential reasons Marcus's attorney had prepared with the precision of someone who knew the allegation would be made and had anticipated how he would dismantle it. The first was that shift records showed no prior encounter between Stone and Marcus that established any familiarity sufficient to justify testing language. The second was that no departmental training protocol included or authorized the use of language of that kind in any context. And the third was that Marcus's camera had captured Stone's posture and tone with enough clarity that anyone watching the recording could independently assess whether what they had seen was consistent with training or with something categorically different from training. Stone's camera had captured something that Marcus's camera had not captured with the same clarity, which was Stone's expression in the seconds immediately before he said the words. Stone's camera was positioned on his chest, pointing slightly upward at the characteristic angle of body cameras, and had captured Stone's face as he bent slightly to examine Marcus's credential, and then straightened to look at Marcus's face before speaking. Behavioral analysis specialists who had been consulted by Marcus's attorneys described what the camera captured in those seconds as the sequence of expressions of someone who had received information contradicting a previously formed expectation, the credential confirming Marcus was a police officer, and who had made a deliberate choice to ignore that information in favor of the conclusion they had brought to the encounter. That specific detail, visible in Stone's recording but not fully captured in Marcus's, had been described by Marcus's attorney during settlement negotiations as the element that transformed the case from a case of words said impulsively into a case of words said after the information contradicting them had been received and processed, which was a distinction that had legal implications about the question of intent that were difficult to ignore. The internal investigation had concluded in 6 weeks with a dismissal recommendation that had been the fastest the department had produced in a conduct case involving discriminatory language in the previous 8 years, according to sources familiar with the department's history. That speed had been interpreted differently by different observers, some seeing it as a sign the department had immediately recognized the gravity of what had happened and had responded proportionally, others seeing it as a sign the department had immediately recognized the risk of going to trial with those cameras and had treated the speed of internal resolution as a form of damage control before the civil lawsuit established the pace of the public narrative. Those two interpretations were not mutually exclusive, and there was available evidence to support elements of both, which was precisely the kind of ambiguity that cases where institutions respond quickly, but for reasons that mix genuine recognition with strategic calculation frequently produced. Stone had attempted the appeal the union had filed on his behalf, and the arbitrator had denied it after a hearing where the cameras had been the central element. The arbitrator had written in the decision's findings that he had watched both recordings 4 times before writing the decision, and had reached the same conclusion on each viewing, that there was no available interpretation of the recorded words that made them compatible with acceptable professional conduct in a department that had explicit policies on discriminatory language in the workplace, and that the existence of prior complaints in Stone's record made it impossible to treat the incident as an isolated deviation without established pattern. The decision had been cited in subsequent legal analyses as an example of arbitration findings that used body camera evidence with a specificity that arbitrators in prior cases without recordings rarely managed to apply for lack of comparable objective material. The civil lawsuit had been filed in state court 3 weeks after the conclusion of the internal investigation, in a timing that had been deliberate in the same way other elements of Marcus's strategy had been deliberate since the first radio call that afternoon on the highway. Marcus's attorney had explained the reason for the timing in one of the preparatory meetings, with a clarity that Marcus would later describe as the explanation that had transformed his understanding of what he was doing from a personal complaint into a strategic process with objectives that went beyond his individual case. Filing the lawsuit after the conclusion of the internal investigation meant the lawsuit benefited from the investigation's conclusions as corroborating evidence without being limited by them, because the internal investigation had concluded that Stone had violated departmental policies, but had stopped short of quantifying the harm or addressing the question of institutional responsibility for the pattern that had allowed that behavior to persist for 12 years. With 3 complaints and a verbal warning as the accumulated response. The lawsuit had been built around 3 central allegations that operated in layers of progressive legal complexity and progressively greater institutional responsibility. The first was the most direct, racial discrimination in the workplace by a colleague, grounded in the words captured by both cameras and in Stone's history that established pattern. The second was institutional supervisory failure, grounded in documents showing the department had been informed of Stone's behavior through 3 complaints over 12 years, and had responded in ways the lawsuit argued were systematically insufficient to produce behavioral change, with the verbal warning for the third complaint being described specifically as a response that had documented recognition of the problem without imposing a consequence capable of modifying the pattern. The third allegation was the one that had generated the most internal debate before being included, and that Marcus's attorney had described as the most important for the objectives Marcus had articulated from the beginning, which was the allegation that the department had created and maintained a work environment where a black officer could be approached by a white colleague as a suspect on a highway, where the words "you are nothing" could be said to a uniformed officer on duty, and where that officer had completed 7 years of service without the department having implemented sufficient policies or training to make that encounter impossible or at least unlikely in its most extreme form. The department had responded to the lawsuit with the strategy departments use when factual evidence is irrefutable, but institutional responsibility is contestable, which was to concede the basic facts while contesting the characterization of the institutional response as systematically inadequate. It had agreed that Stone had violated policies, had agreed that the internal investigation had concluded correctly, had agreed that dismissal had been the appropriate response. It had contested the allegation that the history of responses to Stone's prior complaints constituted institutional negligence, arguing that each complaint had been investigated in accordance with the procedures in effect at the time, and that the adequacy of historical procedures should be evaluated by the standards of the time, and not by the standards the lawsuit was applying retroactively. That line of defense had encountered an obstacle Marcus's attorney had anticipated. The third complaint, the internal one from a black colleague, had been made only 18 months before the incident with Marcus, and the procedures in effect at that time were the same procedures in effect at the time of the incident, which made the argument of evaluation by historical standards inapplicable to the most recent element of the pattern the lawsuit was establishing. The video had become public during the negotiation period that had occurred in parallel with the formal lawsuit, not as the result of any strategic decision, but as the result of a public records request that had reached the department from a journalist who had received information about the lawsuit's existence through the court's public records. The publication had occurred at a moment when negotiations were at a phase where the department had made an initial offer that Marcus's attorneys had rejected as insufficient in both the financial amount and the institutional conditions, and had created additional pressure on the negotiation process that both sides had calculated differently. The department had calculated that the video increased the urgency of a resolution before the public narrative became more difficult to manage. Marcus's attorneys had calculated that the video strengthened their position in the negotiations without eliminating the need to continue pressing for institutional conditions the department had shown reluctance to accept. The reaction to the video had a specific dimension that distinguished it from other police conduct videos that had circulated in the same months, which was the dimension of how the audience watching it processed the fact that both men in the recording were police officers. There had been comments that had circulated widely that touched on that element in ways that revealed something about how people process discrimination within institutions that are frequently framed as monolithic in public discussions about policing, but that are composed of people who experience those institutions in dramatically different ways depending on who they are. Black officers from across the country had shared the video with comments describing similar experiences with a specificity that indicated what had happened to Marcus on a highway was not anomalous, but was part of a set of experiences that existed inside police departments the same way it existed outside them, that the uniform did not eliminate prejudice, but compressed it into interactions that were frequently more difficult to process because they happened in a context where professional fraternity should be the dominant element and where the reality of prejudice made that fraternity asymmetric in ways the uniform did not resolve. Marcus had given an interview during that period to a publication specializing in law enforcement and civil rights issues, the only one he had granted before the case's resolution, and had said something that had been cited in subsequent analyses with a frequency indicating it had touched on a point that longer and more elaborate analyses had tried to articulate without achieving the economy Marcus's words had achieved. He had said that the hardest thing about what had happened on that highway had not been the words themselves, although the words were what was documented and what the lawsuit was addressing, but had been the confirmation that the uniform was not protection against the kind of assumption that had motivated Stone to return after passing, and that confirmation had come from a colleague who had taken the same oaths as him, who had gone through the same training as him, and who had chosen on a highway shoulder on an ordinary day to treat those oaths and that training as secondary to an assumption that the training should have eliminated and that the oath should have prohibited. The $200,000 agreement had been signed 4 months and 11 days after that afternoon on the highway, in a negotiation process that had been longer than the final amount suggested when considered in isolation, because the amount had been the easiest element to negotiate, and the institutional conditions had been the element that had consumed most of the time and energy on both sides. The department had arrived at the $200,000 figure with relative speed after the cameras had been watched in formal negotiations, and after the department's attorney had made the assessment that legal advisors make when evidence leaves no space for alternative narrative. What had taken longer were the pages of the agreement that had no numbers, the pages that described what the department had agreed to change in the way it operated, and those pages had been negotiated with an intensity the financial amount had not required, because the department had understood that the operational changes had implications that would persist long after the check was deposited. The condition that had been most resisted by the department, and that Marcus had told his attorney was non-negotiable from the first meeting, was the condition on specific field colleague recognition training. The department had argued that agents had procedures for identifying other agents, and that those procedures were sufficient. Marcus had told his attorney that Stone's camera had shown Stone examining Marcus's credential and saying, "You are nothing afterward," which was the most direct documentation available that existing procedures had not been sufficient in that specific case, and that the insufficiency had not been accidental but had been a choice. The agreement had included the condition, drafted with a specificity that made compliance verifiable, requiring documented semi-annual training on interactions between agents from different units, with specific emphasis on authority recognition and colleague approach protocol, with a completion assessment that could not be satisfied by attendance alone, but required demonstration of understanding of the scenarios presented. There was a second condition that had been included at Marcus's attorney's insistence more than at Marcus's insistence, but that Marcus had supported after understanding the implications. It was the condition on the automatic complaint escalation mechanism, which required that any second complaint against an agent within a 5-year period be automatically escalated to a supervisory level above the direct supervisor without the direct supervisor's discretion about that escalation, and that any third complaint be automatically referred to a review conducted by an evaluator external to the department. That condition had been the one the department had resisted most vigorously, arguing that it eliminated necessary supervisory discretion and created bureaucratic processes that would compromise operational efficiency. Marcus's attorney had responded that Stone's history had 3 complaints over 12 years that had been handled with supervisory discretion, and that the result of that discretion was documented on 2 body cameras on an American highway. and that if there was a case to illustrate what happened when supervisory discretion was the only escalation mechanism in situations with established pattern, that case was precisely this one. The condition had been included in the agreement. Stone had left the department without possibility of further appeal after the union's third instance had been denied. He had attempted to obtain employment at 2 departments in adjacent counties, and in both cases, the records that included the dismissal and the discriminatory conduct notation in the employment file had resulted in rejection during the background check phase. Marcus's attorney had learned of those attempts through channels he had not detailed but had mentioned in a conversation with Marcus, and Marcus had responded with something the attorney had later described as the response that had revealed more clearly than any formal statement Marcus had made throughout the entire process what had motivated every decision he had made since that afternoon on the highway. Marcus had said he had not sought to prevent Stone from working elsewhere. He had sought for the record to exist, so that anywhere Stone tried to work could make an informed decision about what it was hiring. The difference between those two things mattered to him, and had mattered in every decision about what to include and what not to include in the agreement's conditions. Marcus had returned to service during the negotiations period, had completed the shift that had been interrupted by the afternoon on the highway and by everything that had followed, and had continued doing what officers do when there is no specific call, covering the routes, observing, being a visible presence on the highways he knew well. Colleagues had approached him during that period in different ways, some with the direct solidarity of people who understood what had happened and what it had cost, others with the discomfort of people who were close to something that disturbed categories they had depended on to organize their experience of the institution where they worked. Marcus had navigated those interactions with the same economy with which he had navigated everything else since that afternoon, without dramatizing, without minimizing, present in the work in the way the work required. The agreement had been announced in a joint statement that had been shorter than statements in similar cases normally were, and the brevity had been noted by people following these cases as a sign that both sides had reached a resolution that had not left either of them with excess language to offer. Marcus had given a 1-paragraph statement that had been published alongside the statement, and that had said the agreement was fair, and that the institutional conditions were the outcome he had sought since he had written the first report that night after returning from the shift. He had said the camera had done the work cameras are supposed to do, which was to document what happened regardless of who was being documented, and that what had happened on that highway had mattered not because it had happened to him, but because it happened, which was the distinction that had driven every decision he had made about how to respond. The following morning, Marcus had left home with the uniform and the camera clipped to his chest and had activated the recording the moment he stepped out of the cruiser, as he always did, automatically, without thinking, because that was what you did. The camera had begun recording, and the highway had been there as it always had been, open, long, with the blue sky above and the asphalt stretching on the horizon, waiting for the shift still to come.
Truth is a continuous pursuit, and awareness is your best defense. Thank you for watching and championing global transparency.